Today we have the pleasure of listening to Eva Bernet Kempers, who is a visitor at the Cambridge Centre for Animal Rights Law. Eva is writing her PhD in law at the Animal and Law Chair of the University of Antwerp in Belgium, and is also a junior fellow at the Global Research Network's think tank on animals and biodiversity. Eva holds a BA in anthropology and obtained an MA in global criminology, and holds a Master of Law also from the University of Utrecht in the Netherlands. During her time as a visitor at the centre here in Cambridge, Eva aims to develop a continental perspective on some of the fundamental questions of animal law, illustrating how the assumptions underlying the common law case for animal personhood might have to be adjusted to some degree in order to fit the civil law context of continental Europe. Now, that's also a topic that she'll be talking about today with us in her presentation entitled Animals as Legal Persons, a Necessity or a Luxury, a Perspective from Continental Law. Eva, thanks a lot for being with us here, and the floor is yours.
Thank you very much, Raphael, for this kind introduction, and also for having me as a visitor at your center. I will now try to share the screen with you to share my presentation. You see, I think like this, it should work.
Yes.
Okay, great. So, well, Raphael already introduced me. I'm doing my PhD at the University of Antwerp at the Animal and Law Chair, which was established about 2.5 years ago. And I'm currently a visiting student at the Cambridge Centre for Animal Rights Law, focusing on a project that aims to develop a continental European perspective on some of the central questions of animal rights law. So today I will be focusing on the topic of animal legal personhood, as the title already implied. So the origins of this project are actually quite personal, because when I started my PhD about 2 years ago, I of course read everything I could find on the topic on animals and law. And I discovered that much of the literature I came across was very much centered and focused upon the Anglo-American world, the common law tradition. So this always stayed with me. And when I went to look at the actual continental context in which I was focusing in my PhD, Western European countries, I found that I had to revise some of the assumptions I had about habeas corpus petitions, for instance. So when I got this visiting fellowship, I thought it would be the perfect occasion to look into this issue. And this project is quite recent, so I started working on it only some weeks ago, but I'm very happy to share some preliminary insights, and I'm very open also for all types of advice and critique. So in my presentation, I will be using the quite broad terms common law on the one hand to refer to the Anglo-American common law tradition, and continental law to refer to the civil legal tradition of Western European countries. And of course, I'm aware that there's also very many differences between the jurisdictions that I group together. So I don't want to imply that France and the Netherlands are exactly the same, and I will try not to generalize too much. But what I'm interested in is whether there are some implications of the differences between these two traditions that are relevant for the assumptions relating to animal legal personhood. So to give a short introduction, I think many of you, at least the ones that are familiar with animal law, when I mention animals as legal persons, I think there will be this image popping up in your heads of Stephen Weiss and his non-human rights project, which is, I think he's one of the animal advocates who managed to attract most media coverage and attention for his cases, his habeas corpus petitions on the behalf of individual animals. And for the ones that do not know him, his main aim is to get an American high state court declare an animal legal person, changing its status from property to person. And he often uses this pyramid to explain how the reasoning of the court should go. It should start with the question, is the entity a legal person? Because to Weiss, this is the capacity, the condition for an entity to ever possess any legal rights, level 2 legal rights. The next question is whether or not there's a private right of action, of which habeas corpus is an example. And lastly, at the fourth level, the question of standing, whether the plaintiff has the standing to sue. So this really shows his perspective on personhood as a condition, as the very basis. And one of the latest cases was Happy the Elephant. It was again a habeas corpus petition in order to free Happy from her unlawful detention. I won't go in too deep into the details of this case, because I think next week or the week after we will also have a whole lecture about it. But I was watching these pleadings of Stephen Weiss, because due to the corona situation, we have this unique insight into the American courtroom. And there was an interesting question posed by the judge. So I will try to share a short fragment thereof, in which we see this New York Supreme Court and a judge asking a question to Stephen Weiss, who answers it. Stephen Weiss makes a clear point here, which I would not necessarily disagree with. He really emphasizes the change should not come from the legislature. It should come through the judiciary, because we are speaking here in a common law context. This is a common law writ based upon the common law right. And when I was watching this, the main question that arose was, well, but what about the legal systems that do not have such a writ, that the legal system outside the common law world, in which change, at least primarily, should come from the legislature? So to be clear, my aim of this presentation is not to critique Weiss's strategy, but rather the argument I want to pose is that this view of animal personhood, of animal legal personhood as the condition, as the very basis, should be radically altered when we to make it more tailored to a continental law context. So I would propose a different and alternative animal rights pyramid, which is more tailored to the continental law, in which change, at least primarily, has to go through the legislature. And this pyramid, for this pyramid, I use a distinction by Saskia Stucki between simple rights and fundamental rights, and I build upon the bundle theory of personhood by Visa Kurki. And I will explain a bit more in the upcoming part. But one of the most important differences, as you can see, is that legal personhood is no longer at level 1 at the bottom, but at level 4 at the very top of the pyramid. And this is also a bit what I try to say with the title of this presentation, which sounded a bit vague maybe to some of you. But instead of the necessities, instead of the very basis, the condition for any entity to ever possess legal rights, in this pyramid, which is more tailored to a continental law context, I put legal personhood at the very end, a luxury that might not be necessary for all animals to ever reach that level. And what I mean exactly by this will also hopefully become more clear. Another important difference is that where Stephen Weiss regards legal personhood as a way to become visible to law, because when you're not a legal person, you're just defined by your status as property. In this alternative animal rights pyramid, the visibility of an animal would increase when it moves upwards in the pyramid, becoming more and more visible when approaching legal personhood. So in this lecture, my main aim is to propose this alternative animal rights pyramid as more tailored to continental law, and also to demonstrate its relevance for the legal approach to animals. In the first part, I will explain shortly the levels, the different levels it consists of. And in the second part, I will apply it by using some examples or case studies in continental law. And I will be taking the positive law as a starting point. So I won't be concerned too much with normative questions, normative arguments with regard to the rights animals ought to have. And I speak primarily about legal rights and not about moral or political rights in that regard. So let me start with a short discussion of this alternative animal rights pyramid. At the first level, we find simple rights, which are by Saskia Stucki defined as implicit weak rights. They are the other side of the coin of a legally codified duty. So they exist as soon as a legally codified duty exists towards animals. And I won't go in too deep into the Hoffeldian relationships on which this idea is built, but it is important to get the concept of weak implicit legal rights that are generally not recognized as rights by courts. Examples of simple rights can be found in animal protection acts, such as the duty not to unnecessarily harm animals, which can be read as a simple right not to be unnecessarily harmed. But again, as I said, these are very weak, so not very many legal scholars would describe them as rights, although there are some, like Kastenstein, for instance, who do describe such protections as actual legal rights. An important condition is that animals are the intended beneficiaries of the duty, because that distinguishes also simple rights from, for instance, duty to stop for a traffic light, which is often an example given. Such a duty, of course, cannot be read as a simple right of the traffic light, because the traffic light is not an intended beneficiary of such duty. So simple rights should always be distinguished from fundamental rights, which are much more stronger, explicit rights that differ from simple rights by the following two aspects. They protect fundamental interests, so no trivial interest like the interest not to be slaughtered without stunning, which is not a fundamental interest that could ever be a fundamental right. And they have a stronger normative force. So in theory, some simple rights could be turned into fundamental rights, but not all of them. So these legal constructs are much more like what we understand with human rights. Examples, like I said, I would say that some of the simple rights you see today could be turned into fundamental rights when they comply with these two factors, the normative force and the fundamental interest. But also bans prohibiting certain harmful practices to animals can be regarded as a form of fundamental rights. An international convention, in theory, when it ever would be adopted, would be providing fundamental rights to animals. Also, for instance, constitutional rights, for instance, to sovereignty. If you're interested in that topic, there will also be a lecture about it by Pablo in a couple of weeks. And yeah, so that's the important things to remember about fundamental rights, and why I put it still on level 2 and not. So what I implicitly argue is that animals can have such fundamental rights without being actual legal persons. It's only at level 3 that we get closer to legal personhood. And there I built upon the bundle theory of personhood by Visakirki, which regards personhood as a bundle of interrelated incidents, of which different entities can have different incident to a different degree. So this means that a certain entity, a non-person, could gain gradually personhood-related benefits and burdens. And in fact, this is a bit the road that slaves, for instance, took, or women and children in most jurisdictions, from being largely defined by their status as non-persons. They gradually gained personhood-related benefits and burdens. And again, what this implies is that a certain entity X can simultaneously be the property of someone and endowed with numerous incidents of legal personhood. So it is something else than to have certain specific selection of incidents of legal personhood would not automatically make you a legal person and legal person to court. So examples of relevant incidents are, for instance, to have standing in courts, to be a victim of crime, to undergo legal injury, receive compensation. But these are only examples. I think there might be more incidents that are relevant. And I think this theory is really also confirmed by empirical observation. For instance, when I see in Belgium, there are certain organizations labor unions that are not legal persons, but they can still initiate procedures, for instance. So with the help of this theory, we can see them as non-persons that possess a certain incident of personhood that makes it possible for them to initiate procedures. And arguably, I would also propose to see the capacity to have your interest recognized in private law as some kind of incident of personhood that could be possessed by animals. But I will come back to that. And I'm not sure whether Visa would agree with that addition. So only at the last level, at level 4, I would put legal personhood. And hereby I mean just the full personhood which is recognized by the legal system as such, which implies not being property, because there would be no jurisdiction that would be willing to recognize one and the same entity as property and as full person at the same time. To regard legal personhood as such makes it an institutional fact. It is a conclusion and not so much a reason. So it's perceived in a different way than Weiss uses this concept. Okay, that was shortly the pyramid. Now I will have a more exciting discussion of some case studies and examples from continental law. And my secondary aim is also just to shed some light on in interesting developments that are happening. So I will look at these 4 examples of dogs, chickens used for meat production, minks used for fur production, and wolves, and use this pyramid to show their legal position, to illustrate their position in continental law. So first, with regard to dogs, the first question to be asked is whether or not they possess simple rights. And I think we can conclude in the way I define simple rights that dogs possess definitely some simple rights. For instance, the simple right not to be unnecessarily harmed by any human. And this is a duty that is codified in all continental jurisdictions. It's one of the basic duties in animal protection acts. But as I said before, a condition for something to be considered a simple right is that animals are in fact the intended beneficiaries of such duty. And if we look at the situation about 50 years ago or 60 years ago, most animal protection acts were actually motivated. The anti-cruelty statutes were very much motivated by the aim to protect property, for instance, or the aim to protect the public order. So such anti-cruelty statutes would definitely not be considered as possibly simple rights. Today's animal protection acts of continental European countries, however, they clearly have animals as their beneficiary. To mention some nice examples, because every country really has their own kind of legal discourse with which they approach the issue of animal protection. For instance, in Germany, animals are regarded as fellow beings, Mitgeschöpfe. In the Netherlands, animals are recognized as intrinsically valuable. And this is a concept that has stood central already since 1981. And it's really clearly stated that this means that the interests of animals should really be taken into account in a conscious balancing process. In the region of Brussels, Luxembourg, and Switzerland, animals are recognized as dignified beings. And in France, this idea of sentience stands central. So I think we can argue that these animal protection acts nowadays, at least, do really have animals as their intended beneficiaries. And thus can be read as some form of simple rights. As I said before, however, these are very weak rights. They are generally not comparable to human rights in any way. They are easily disregarded. So a more interesting question is whether dogs would also have some fundamental rights today. And I think this is debatable. On the one hand, you can say that they have quite a strong claim to care by their owner. But as I said before, there need to be 2 factors complied with. It needs to be a fundamental interest and there needs to be a strong normative force. So on the one hand, you see that if you neglect an animal, it can easily be taken away by the state. So in a sense, it has some force and weight in the balancing. But still, another characteristic of fundamental rights is that they are explicitly legal rights, and that is not the case with the current Animal Protection Acts generally, although there are some examples. There's some exceptions. For instance, the Court of Appeal last year stated that animals do in fact have legal rights, and also the new Animal Protection Act of Luxembourg is described as this new law grants animals new rights that can be asserted in their favor. But these are very rare notions. Nevertheless, I do think that such strong duties towards dogs, towards companion animals, could maybe evolve into something closer to fundamental rights. Then the question whether they have any incidents of legal personhood. Again, I think this could be debated. I would say probably not at this moment, but there are some interesting developments happening. For instance, in France and Belgium, it becomes more increasingly easy for organizations to go to court on behalf of animals. And for instance, in France, there's an article of the Code of Penal Procedure that states that any organization which aims to protect animals may exercise the rights recognized to the civil party with regard to the offenses provided for by the penal code that punish abandonment and abuse of animals. So in fact, what this means is that such organizations can exercise those rights that victims are usually able to exercise. So they can also go into appeal, for instance, or they can receive compensation to take care of the medical costs of animals. And however, I put a question mark below the in name of, because it's not literally, of course, recognized that the animal is the victim here. So what you could argue is that there's a procedural aspect of standing present, but the invested aspect of standing is still lacking here, because it's not really in name of the animal. It's because they protect animals in their statutes that they are recognized as civil parties. However, again, I think that such constructions do have the potential to evolve in something that might be regarded an incident of legal personhood. Another interesting development in this context is the increasing visibility of companion animals like dogs in private law cases. For instance, in divorce cases, there's this growing tendency of judges to actually take into account the interests of the animals. For instance, when there's a conflict between the parties about who can have the animal, who can have the dog, there are certain there's an increasing amount of case law in which the court actually refers to the interest of the dog as a relevant aspect in the balancing. And this is also the case in compensation cases, where this difference between the dog and other forms of property is increasingly recognized. And well, if you would say that only when they are full legal persons, dogs become visible to law, this kind of challenges that idea, because these courts already clearly regard animals as something different from other forms of property. So if we then have to place dogs somewhere in the pyramid, I would say that they are at least quite high compared to other animals, but whether they have any fundamental rights remains very debatable. And also the incidents of legal personhood are still very, very limited. So the second case study I wanted to discuss is chickens kept for meat production. And again, the first question then is whether or not these chickens have simple rights. And in theory, those animal protection acts that were applicable to dogs are of course also applicable to chickens. However, in practice, I see a very different picture. For instance, in most continental European countries, the production animals used for production are largely regulated by European directives. And these directives, they don't even refer to chickens or individual chickens, but to kilograms. for instance, in this article, member states shall ensure that the maximum stocking density does not exceed 33 kilograms per meter. So I don't think you can in any way describe such directives as simple rights on behalf of chickens. It is clear that they do not formulate any direct duties to animals. Apart from that, there's also the enforcement norm, which means that states, many continental jurisdictions do not enforce any animal protection regulation as long as the injury and death in a certain facility remains below 2%. So actually, this is a very different situation than you saw with dogs. I would say that chickens kept for meat productions do not have any simple rights in reality at this moment. So this becomes extra clear in an interesting case 2 years ago, in Dutch case, in which a woman was charged for animal abuse because she kept 3 chickens on 1.3 square meters. And according to the Animal Protection Act, a chicken must be kept in line with its etiological and physiological needs, which means that it would need about 1.5 square meter per chicken, according to a university report. However, in the industry, chickens kept for production are kept at 9 chickens per square meter. So the appellant made the argument that the legislature can never have meant to allow a certain amount of space for chickens for the industry, but qualify that same amount of space as animal abuse when the chicken is privately kept. And I think she makes a really good point here, because this is just a clear discrimination, if you ask me. And the judge, unfortunately, reasoned the other way around and said, well, the way chickens are treated in the industry should not be an excuse to abuse chickens at home, which is, of course, also true. But still, I think it's very problematic that we have such democratically established Animal Protection Act that are, in fact, not applied to those chickens kept for meat production. So I would say that chickens kept for meat production do not even enter the alternative animal rights pyramid in any way. They are outside. And then the third case study I'd like to discuss is minks used for fur production, which is just a very, very short one, which I wanted to discuss for a different reason. Because minks might have some degree of simple rights when they are kept for fur production, but very limited. And in the Netherlands, which was the 4th biggest mink fur producer of the world, there was already a long debate about whether or not keeping minks for such purpose is legitimizable, because minks are wild animals, they live solitary. And eventually it was decided that there would be a ban on using minks for fur production per 2024. So according to the way I define the fundamental rights, such ban can be regarded as a fundamental right not to be used for fur production for minks. So, which means that the minks actually, at this level, obtain a fundamental right not to be used for fur production, which renders personhood for them quite unnecessary in a sense. Of course, there are still minks, but they are wild minks that are in a very different relationship with humans and have a very different need for different rights, I would say. And I think this is the same for instance, circus animals, wild animals used in circuses, which is now prohibited in most continental jurisdictions. And in theory, it would also be the case with laboratory animals, once using them for experiments would be prohibited. So this is another way in which I would argue that you could regard legal personhood as a luxury rather than necessity, because for some animals, just having the fundamental right not to be used by humans for a certain purpose already would bring them to the level 2, and would kind of their legal existence would cease to exist in a sense. So last, I want to shortly discuss the example of wolves because they are wild animals, of course, and they're therefore a very interesting, different kind of situation. Because whether or not the wolf has any simple rights depends very much on which jurisdiction we are looking. In the Netherlands, the Wet Dieren, the Animal Protection Act, there are some provisions that explicitly extend to wild animals. For instance, prohibition to abuse animals, which extends to wild animals, and the obligation to provide the necessary care for animals in need of help also extends to wild animals, which is interesting because it would almost imply that you are obliged to save a deer from being eaten. So it's probably not really a provision that will be enforced often, but still in theory, the wolf has a simple right on this kind of help. However, when they enter France, there are no duties towards wild animals codified. As far as I'm aware, correct me if I'm wrong, but most of or as far as I know, all of the animal protection provisions only apply to wild animals kept in captivity or domesticated animals. So a wolf would, in practice, lose its simple right as soon as it crosses the border to France. However, with regard to fundamental rights, there's a increasing number of scholars who have argued that the wolf in continental Europe actually has a fundamental right to life, and I would rather call it a fundamental right not to be killed by humans, that can be found in the Habitats Directive. Article 12 of this directive requires member states to prohibit all forms of deliberate capture or killing of specimens of the species that are listed on Annex 4. And the wolf is listed on Annex 4. So this is quite a strong provision because no specific intent needs to be proven. It's clear that there is a substantial interest protected. And it is also given substantial weight. The prohibition to kill wolves extends to wolves that enter, for instance, human villages. That became clear a couple of months ago. However, there's also derogations to this rule. So that makes it again very questionable whether this is really a fundamental right. But what is interesting is that it follows the wolf. So when the wolf enters a new country that it has never been before, that jurisdiction is immediately under an obligation to provide this strict regime of protection. So does the wolf then possess any incidence of legal personhood? That's definitely not the case. And that became really clear in a recent case of Naya here in Belgium. And that was a very popular wolf, a bit like Cecile the lion some years ago, in which there was also a lot of attention, media attention for the killing. And that was certainly the case with Naya as well. There was the headlines in Belgium all spoke about the murder of Naya and the search for the murderer, which is interesting to see that, but in the public, it was really clear that this constituted a murder. Of course, in the legal sense, that was not the case. But there was nobody who actually could go to court and claim damages or initiate procedures. So that makes it very clear that wolves do not possess that incident of legal personhood that would make that possible. So if I have to place wolves somewhere in the pyramid, I would say it's again debatable, and I'm open for discussion whether this can be regarded a fundamental right not to be killed, but probably somewhere about here in between the fundamental and simple rights. So to get to conclusions, what I've tried to do in this lecture is to provide a kind of alternative way of approaching the question of legal personhood for animals that might be more tailored to a continental law context in which change has to go primarily through the legislature, in which personhood cannot be established on a case-to-case basis. So the idea or the hypothesis I defended is that whether it's actually possible to get to animal rights through personhood, and whether it's not more likely to see it the other way around, to get personhood through rights. And then if we look at it that way, then personhood might sometimes be regarded a luxury rather than necessity, as some animals will only need the fundamental right not to be used in a certain way. So some preliminary insights we could draw maybe from this first study is that there might be a need to diversify some of the assumptions of animal rights law, because they could be embedded in common law doctrines that do not fit necessarily a civil legal tradition. And also in the second part, what I've tried to make clear is that it's not always helpful to speak of just rights in a general sense of the animal, as well, with the word rights, we can already mean a lot of different constructs, and also the animal in law is hard to define, as there are very many different animals with whom we have very different kind of relationships. So like I said before, it's really in the first stages, this project, so I'm very much looking forward to your critiques, suggestions, and advice. And I think I probably said a lot with which you could disagree. So I'm curious to hear more. And I also invite you all to join a roundtable in which I will discuss this further together with some continental animal law specialists that will take place in March. So thank you very much for your attention. Curious to hear more.